Hi, everyone. Thank you so much for joining us tonight. We're not going to be starting just this moment. We want to give everyone a chance to log on, get settled, get comfortable, get a glass of water if you would like, walk around if you would like. Yeah, just a moment for everyone to log in. We don't want to start too early so that people don't miss any information, but we do want to be respectful of everyone's time, for those of you who are here on time. So kind of a meet in the middle. We'll start around 6:05. And we'll go through some introductions. We will be taking a poll, a few more introductions, and then we're going to hop right into the presentation that leads into a Q&A section. So that's about how the evening's going to go. We'll be answering questions, like I said, at the end. But in the meantime, please feel free to drop your name in the chat if you're comfortable. What borough you're calling in from. You could do the borough, you could do the zip code. If you're calling from out of state, out of New York State, feel free to drop the state. And additionally, if you're a homeowner, how long have you been a homeowner? And if you're not, would you like to be a homeowner? Any information that you'd like to share about yourself in the chat, please feel free. So yeah, we'll be starting in just a little while. Okay, so it's 6:06. Feel free to keep dropping in all that information into the chat, whatever other information you're comfortable sharing. But we are going to get started right now. So hi, everyone. My name is Ariana Baldwin. I'm the Senior Coordinator of Outreach and Partnerships at Grow Brooklyn. And I will start by thanking you all for joining us tonight, taking time out of your busy schedules to sit down and learn with us and, engage in this community education campaign that we have going on that we offer monthly to the community. So yeah, this is part of Generation to Generation. This is part 2 in a 2-part webinar series. This part is called Estate Probate and Administration. Yes, as I said before, second part in a 2-part webinar series. And like I also said before, we put it on every month. So if you missed last month, hopefully maybe you're joining us for this month. If you know of somebody who's not able to make it to this month, let them know that they can join us in February, and so on and so on. But yeah, we basically put this on monthly in a regular way so that homeowners can be informed about the importance of estate planning services as a tool that they can use to grow and secure generational wealth, to mitigate the effects of gentrification, and to increase homeownership retention rates. So we're going to take a few minutes to do a poll that we would really appreciate you all participating in. Give me 1 second to end the screen share, and I will launch the poll right now. Let me know if you guys can see that. If someone could let me know in the chat if that's working, or you could just start taking it and I'll be able to see that people are able to see it. Yes, someone says yes. Okay, great. Thank you. So yeah, so this poll is essentially a way for us to hear from the community, hear from you guys. What do you guys think we can improve on in terms of outreach, in terms of getting the word out there, and also the level of knowledge that you have about estate planning, because we want to try to meet people where they're at. So learning that information about you guys is really, really helpful to us, and we're able to grow, you know, the work that we're doing and improve what we're doing. I see people taking it. Awesome. Thank you so much, guys. Yeah, it's just 5 quick questions. The first question is, how much do you know about estate planning legal services? Options are a lot, a little more than the average person, an average amount, a little less than the average person, or not at all. As of right now, we have 40% of people saying a little more than the average person. Next question, did you know that this program, G2G, Generation to Generation, or Gen to Gen, is offering free estate planning legal services? 50% said yes and 50% said no, so we're split right down the middle for that one. Are you interested in getting these free estate planning legal services? 63% said yes, that's awesome. Do you know who to contact in order to start using the services that this program provides? 71% said no. Thankfully, you are in the right place to learn that information. Yes, so, and then the next question, how would you suggest that we expand our outreach / advertisement for this program? And you could select all that apply. So if you think that it's just one, click that one. If you feel like more than one apply, please feel free. Click as many as you would like. 74% is the leading answer. Actually, we have a tie, 74% between more webinars on Zoom and more emails. So we're going to leave this up for a few more minutes to give everybody a chance. Looks like we're at 64% participation. Let's try to get it to 100%. We always love to see that. But yeah, we'll leave it up for a few more minutes to give everybody a chance to take it, and then we'll close it and get going. Thanks, guys. Looks like we're at 65%, guys. Still a tie between, for the 5th question, there's still a tie between more webinars and more emails. That's great feedback. We appreciate that. I feel like a sports commentator, but the tie has been broken. 73% for more webinars and now 68% for more emails. We'll give it a few more seconds and then we'll close it out, about 30 more seconds. So if you're just finishing up, try to get it in as fast as you can. And if you haven't taken it, it's only 5 questions, so it shouldn't take you that long. So yeah. Okay, great. So I'm going to close that out. Thank you for everybody who participated. If you joined in a little late and weren't able to participate, that's totally fine. Feel free to come back next month and you can just log in for the survey if you'd like. But yeah, so briefly before we jump in, this is a Generation to Generation G2G event. So we want to tell you a little bit about G2G, a little bit about the Black Homeownership Project, which you might hear referred to as BHP. But yeah, so the Black Homeownership Project came about as one way to address the issue that New York City has lost thousands of Black homeowners over the last decade and could lose even more due to the economic and the health devastation that was caused by the pandemic that we were all impacted by, and some of our most marginalized communities were even more heavily impacted. And we want to take the space to acknowledge that and acknowledge that it didn't impact everybody the same way. And some community members of ours felt that, and some communities overall felt that impact a lot more heavily. So for far too many families, specifically Black families in New York City, inheriting a home does not always lead to sustained home ownership. Deed theft, predatory lending, and expensive entanglements with tax liens and other inherited debts are major, major obstacles to the safe transfer of homes across generations. And in the research that the Center for New York City Neighborhoods conducted while creating this project and before really putting it all together, they found that estate planning resources are underutilized by so many Black homeowners for a variety of reasons, including the lack of affordable services, distrust in the legal system, and a lack of education about the necessity of estate planning and how much of a difference it can really make in keeping your home, retaining it, and sustaining it, and passing it down to your family, your friends, your community, whoever you choose to pass it down to. For too many Black families, they only encounter estate planning when they're in a crisis. Investment in estate planning for low to moderate income homeowners has never been a priority for the city, and it should be. And that leads to some homeowners falling into a gap where they're too house rich to qualify for support, but too income limited to be able to really afford proactive legal representation. And pro bono estate planning legal services has generally been an overlooked area for homeowners who are generally assumed to have the resources to hire private attorneys for these services. But that's not something that we should assume, because that's how we end up neglecting certain members of our community who do need this help. And that's exactly where D2G comes into play. We are providing free estate planning legal services such as wills, last will and testament, living wills, last will and testament, healthcare proxies, power of attorney, and other advanced directives to Black homeowners in New York City, specifically in central Brooklyn, South Brooklyn, and the North Bronx, coupled with, like I said earlier, community education campaign, this is part of that, to raise awareness about the importance of this service and the services that overall are being provided under the Black Homeownership Project and Generation to Generation. We also, so part of Generation to Generation, it's a kind of coalition of different nonprofits. We have NHS Brooklyn, Angela Davidson is on the call tonight. We have Bed-Stuy Restoration Corporation, Anthony Coker is on the call tonight. Nat and myself are from Grow Brooklyn, and we also have NHS NYC and NHS Bronx who are partners on this. I don't know if Angela or Anthony, either of you wants to take a moment to just offer a few words, but if not, then we could just pass it over to Nat to really get into the presentation.
Hi, Ariana, thank you for that. I'm Angela Davidson with NHS Brooklyn. Don't want to take away from Nat's time tonight because he has such important information and so much needed information. As Ariana said, this project is to help us to sustain housing, right? A lot of people, as you know, just to echo some of what Ariana said, received homes from an estate from someone who passed on and not sure what to do, what next steps are, you know, and what are their rights on their receiving home in that way. So tonight is really that time that where you're going to learn all the important nuances and things that you actually are supposed to be doing when you inherit a home. And so not stealing Nat's thunder, he's definitely going to walk us through this. As much as I'm a part of this, I just learn every time I come on these webinars with Nat and Charles. And I see someone, Wendy said thanks. So you guys did a great job with something for her today. So, you know, just add into what Wendy said to say that, you know, Nat and Charles are really doing a great job helping people to create all those documents that Ariana mentioned earlier. So just wanted everyone to know that there are community organizations in your community that you can go to get the intake done, which get passed on to Grow Brooklyn. So if you cannot get to Grow Brooklyn directly, please do reach out to one of the organizations. Our information is going to be at the end of the webinar where you can contact people. And if you've been trying to contact me and I haven't reached out, I haven't lost your emails. I'm going to get back to everyone shortly. Thank you for that.
Yeah, thank you so much. Anthony?
Yeah, I'm just going to echo everything that Angela Davidson said. Me and Angela, we're, are basically the community points of contact for all of you guys. So between the two of us, we have many years of experience in the housing space, and we're here to help you with any housing related issues. Of course, we're partnering with the attorneys here at Brooklyn to help offer you these services. But as we are not attorneys, we can't service those things. But we are also here to basically be the point of contact so that they're not overwhelmed with all these inundated conversations. So if you need help getting an appointment, just reach out to us, and we'll also be able to help you secure that. Thank you.
Thank you so much, Angela and Anthony. So without further ado, Nat, take it away with the presentation. We're gonna hop right in.
All right, good evening, everyone. My name is Nat Sripanya, and I'm one of the staff attorneys at Grow Brooklyn. We are the legal services partner of the Generation to Generation Initiative, or Gen to Gen for short. And as Ariana just explained, the Gen to Gen Initiative is part of the Center for New York City Neighborhoods Black Homeownership Project, focusing on preserving generational wealth by offering free estate planning services. For many New Yorkers, the family home represents the majority of the family's wealth, and proper estate planning can be critical to ensuring that that wealth is not diminished or lost after death, but instead passed on to the next generation. As the legal services partner, Grow Brooklyn's attorneys will be drafting and supervising all wills and other documents offered through the Gen to Gen initiative. I do have to make one disclaimer. The information and materials offered herein are for general informational purposes only, and are not and should not be considered legal advice. Anyone seeking legal advice should consult with an attorney familiar with their situation. All right, can everyone see my slides?
Yes, looking good.
Great, I'm going to turn my video off now. Tonight's presentation is the second in a two-part series on estate planning. Hopefully you were able to attend last week's presentation on estate planning and are familiar with the ways you can protect your assets for your family upon your eventual passing. This presentation will guide you through the steps your family should take immediately after death to protect your home and other assets, and detail the procedure they'll have to complete to transfer those assets, either the probate of your will, or if you don't have a will, the administration of your estate. Please note that throughout this presentation, I'll be using the term decedent to refer to the deceased person, as that's the term used by the courts. I do want to make it clear at the outset that in order to access any individual accounts or transfer individually owned property after death, your heirs or beneficiaries cannot avoid going to surrogate's court. No person has the legal authority to access the accounts or transfer the property of a deceased person. They have to be granted that authority by a surrogate's court of the county where the deceased person lived. And this presentation is intended to help you understand and prepare for that process. Please hold your questions till the end. I'll be answering all of your questions. We have, in the past few presentations, we've had a robust question and answer period. I enjoy the engagement with the community. I'm glad people are paying attention. I'm glad people are asking questions. Once we reach the end of the presentation, you can enter your questions in the chat box or the Q&A, or you can actually raise your hand and ask your question live. Please note though, I will only be answering general questions and not any specific questions. If you have a specific issue, please reach out to the agency through which you found us today for a referral to one of our attorneys. I'd like to begin with the steps that should be taken immediately after death. While this may be a difficult time, this is also a critical period to secure and protect a decedent's assets. You should know that there's no specific order in which these tasks should be completed, but ideally these should all be done within 2 weeks of death. First, the family needs to obtain death certificates, which is done through the funeral home. It's important to get several certified copies, as they're going to have to provide those copies to surrogate's court and various financial institutions and governmental agencies. After the funeral, they should request that the funeral home provide them with a receipt that's been marked paid. The funeral home is going to be expecting this request because the surrogate's court require a paid receipt with all administration and probate petitions. Now, if the decedent died at home and lived alone, the NYPD is going to seal that residence. If the home is sealed, it's going to remain sealed until the surrogate's court process is complete and a representative has been appointed, either an administrator or an executor. The only way to get into a sealed home prior to that appointment is by filing a separate petition with the surrogate's court to search that home for a will or insurance policies. if that petition is approved, upon approval, the search is going to be conducted by a family member under the supervision of the NYPD. And the NYPD will stand there and prohibit the removal of anything from the home except for a will or insurance policy documents. You're not going in and getting jewelry. You're not going in and getting car keys. Those items have to remain in the home. You can get financial instrument documents. That's not instrument, insurance documents or wills. That's it. If the decedent's home is not sealed by the police, it should absolutely be sealed by the family. The family needs to go and secure the home because a vacant property is an ideal target for a burglar or a squatter. In New York City, an intruder who's able to remain in a home for more than 30 days becomes a squatter. Before 30 days, the police can remove them as a trespasser. But after 30 days, the intruder actually gets limited tenancy rights, and the family can only evict them through housing court. That's the only way to get them out. Evicting a squatter through housing court takes months, if not years, and that process can't start until the surrogate's court process is complete, which in and of itself can take months or years. Next, the family needs to inventory the decedent's major assets. These assets are things like real property, that's land, real estate, vehicles, financial accounts, and of course, any valuables. If you have the Hope Diamond, figure out where it is. However, you should be aware that some jointly owned assets, and of course, any asset with a death beneficiary is not included in this inventory. Any asset owned jointly as tenants in common was owned in separate percentages. So say for instance, I, Ariana, Angela, and Anthony own a piece of property as tenants in common, 25% each. If one of us dies, our 25% is included in this inventory. However, any assets owned jointly as joint tenants with right of survivorship automatically transfer to the joint owner upon death. Additionally, any real property owned with a spouse may automatically transfer to the surviving spouse as long as the couple meets the following criteria. 1, they have to be married when they purchase the property. 2, both names need to be on the deed. And 3, the deed has to be silent or not state any other form of ownership. Any assets with a death beneficiary, things like financial accounts, life insurance policies, those belong to their respective beneficiaries. The beneficiary should be able to access those accounts by simply submitting a benefit claim form along with a certified copy of the death certificate. So those assets, you do not need to go through surrogate's court to access those assets. The beneficiaries can simply deal with the financial institution and access them on their own. Finally, the family needs to assess the decedent's finances and get ready to manage their affairs for the period while the surrogate's court petition is pending. So that months or years period where the estate is tied up in surrogate's court, there's no estate representative appointed, the family should be prepared, if they're able, to maintain the assets, protect them. I understand that we have some people who are having trouble seeing the screen. Is that better?
Yes, that looks a lot
Much
better.
better,
Thank you.
Nat.
Yeah.
Yeah,
Great.
very good. Thanks.
Okay. Well, I have a new setup with 2 monitors. I can actually do that now. Okay, so you have to assess the finances and prepare to maintain the assets while the surrogate's court petition is pending. Again, could be months, it could be a year or longer. But during that time, no one can transfer the assets, but you want to protect them. So first, you're going to notify all of the decedent's financial institutions of the death and ask them to suspend late fees, account access, and legal proceedings like collections proceedings against the decedent while the estate is working its way through surrogate's court. The family should also contact all the credit bureaus, all 3 credit bureaus, provide them with death certificates to make sure that no new accounts are open in the decedent's name. Grandma passes away, someone finds out, someone uses grandma's identity to open up a new credit card and rack up, a couple $1,000s in credit card debt. That's a very common crime and can add an additional layer of frustration to an already complicated situation. Furthermore, the family should contact Social Security and any other benefits agencies and provide them with the death certificates, to ensure that they don't disperse any further payments, as post-death payments are going to have to be paid back, and receiving and using post-death payments could result in criminal liability. So once the family has a general picture of the decedent's finances, they'll need to determine which monthly bills, which monthly obligations need to continue being paid in order to protect the estate assets, such as utility bills and homeowners insurance, and which obligations should be paid to avoid additional costs or liability to the estate. Things like mortgage or car payments. If there's a mortgage and the family is able to continue paying it, continue paying it. You fail to pay it, late fees are going to rack up, default interest is going to rack up, the house could end up in foreclosure. And they don't, there are laws regarding suing a dead person. However, they can start the foreclosure proceeding against the property by naming the heirs. We see it all the time. So if you're able to keep up with the carrying costs of a home or the carrying costs of certain major assets, do so. Once the family's completed these steps, the family should terminate unnecessary services wherever possible. Subscription accounts, streaming services. You're not going to need the Netflix anymore. And if that Netflix is billing an account every month, there may not be money going into that account anymore. So the money's just going to keep coming out until that account's drained. Cancel the services, cancel anything that's not necessary. Please note that these are merely temporary measures intended to protect the estate assets until an executor or administrator is appointed by the surrogates court. Once an estate representative is appointed, that representative is going to be able to sell or transfer the assets to the beneficiaries of the heirs. Once the family's completed these steps, they can shift their focus to petitioning the surrogates court to have an estate representative appointed. If a decedent died testate or with a will, the estate representative was selected by the decedent themselves and named in the will. The estate representative is called an executor, and the executor is required to distribute the assets as instructed in the will. The executor's petition to the court is called a petition for probate. Probate comes from the Latin word probare, which means to prove. And the executor has to do exactly that. Prove to the surrogates court that they're presenting the original valid will. If the decedent died intestate or without a will, the estate representative can be any person who's entitled to an inheritance. The estate representative is called an administrator, and the administrator is required to distribute the assets equally amongst the closest living class of family members per New York state law, as follows. If you have a surviving spouse and no children, the spouse gets the entire estate. If there are surviving children but no spouse, the children get the entire estate in equal shares. This makes sense. Now, if there's a surviving spouse and children, the spouse gets the first $50,000 value in the estate and then one half of the rest. And the children take the other half of the rest in equal shares. If a child dies before the decedent but leaves behind grandchildren, those grandchildren split their parents' portion in equal shares. If there are no surviving spouse or children or grandchildren or so on, the estate will be distributed to the parents, and if they're deceased, then to the siblings, and so on and so forth as the classes of family become more and more remote. The members of this closest living family class, the people who are going to inherit, are called the distributees, because the estate is going to be distributed among them. Any one of these distributees, assuming that they're not otherwise disqualified, is entitled to become the administrator. And it's not uncommon for distributees, often estranged siblings, to fight over becoming the administrator. And that can tie up an estate in litigation for years with no one fully able to manage and protect the assets. Minors, people who have been declared mentally incompetent, and in most cases convicted felons, are disqualified from being administrators and executors. Now, this doesn't mean that they lose their inheritance, but it does mean that they're prohibited from becoming the estate representative, because that's a position of trust and responsibility. While the law lays out what appears to be a fairly comprehensive solution to intestate estates, the law is really only effective for happy, cooperative, single marriage, nuclear families, and doesn't account for several real-life family situations. Non-adopted children, even if they're stepchildren or children raised in the household alongside natural-born or adopted children, are not distributees, and they receive nothing if there's no will. So I've had clients call and tell me, I have 4 children and I want to prepare an estate plan. Great. As the conversation unfolds, it turns out that 2 of those children are the caller's natural-born children. The 3rd child is a niece that they took in, and the 4th child is actually an orphan child of a deceased neighbor that's been living with them. Both the niece and the orphan have been raised in this client's home their entire lives, and they've been treated as children and as siblings to their own children. But in the eyes of the law, they're not. If that caller was to die before their will was signed, the caller's niece and the orphan would be entitled to nothing. Caregivers are not distributees, and they receive nothing if there's no will. I've had clients call me and tell me that their children have abandoned them. Their favorite nephew has been caring for them for 20 years. Without a will, the client's estranged children will inherit some, if not all, of the estate, but either way, the nephew gets nothing. New York state law does not recognize common law marriage, and while it does recognize domestic partnerships, domestic partners are not included in the laws that govern estates. A romantic partner, even a New York registered domestic partner, is not a distributee and receives nothing if there is no will. New York state law treats all children as equals. If a decedent has 2 children, it doesn't matter that one child supported the decedent both personally and financially for their entire lives, and the other child has completely abandoned the family. Those 2 children are entitled to equal inheritances. So now that the family has the decedent's finances and assets squared away for the short term, they can focus on surrogate's court. Remember, if the decedent died testate with a will, the executor will be filing a petition for probate. And if the decedent died intestate or without a will, any of the distributees can file an administration petition. For both types of proceedings, the petitioner is going to have to file the following documents. They don't have to file them all simultaneously with the petition, but best practices, at least our office, always prepares all of the documents simultaneously and files them at the same time, because surrogate's court has been backed up for years prior to COVID, and they review each petition on a first come, first served basis. So if your petition isn't complete with all the necessary documents by the time it reaches the top of the pile, it gets shuffled back to the bottom, and that results in additional months of delay. While you may file all the additional documents required, but you're still going to have to wait till your petition gets back to the top of the pile. However, in the event of an emergency, such as a pending foreclosure, ongoing litigation, or other threats to the assets of the estate, a petition can be expedited using an affidavit of urgency. However, even with the affidavit of urgency, the petition simply gets moved from the regular pile to the expedited pile with all the other urgent petitions. So there may still be some delay, and it's always best to ensure that petitions are filed in full with all of the documents necessary as early as possible. First document, of course, is the petition itself. The petition requires personal information about the petitioner, the decedent, details about the current living family members, including their addresses, details from the will, if there is one, and details regarding the estimated total value of the assets of the estate. This estimated value is going to be used to calculate the filing fee, which can be up to $1,250 if the estate is worth more than $500,000. In New York City, filing fees for estates of the majority of homeowners is going to be the $1,250 because of our high property values. The filing fee is due when the petition is filed. However, if the petition is successful, the executor or administrator will be reimbursed for that filing fee from the estate. Petition must be accompanied by a certified copy of the death certificate. Most surrogates court petitions are e-filed, so they're filed online, and a copy of the death certificate is going to be submitted online as well. However, a physical certified copy is required to be delivered within 2 days of e-filing. So if you e-file the death certificate, you e-file a petition, all the documents listed here, someone has to deliver a death certificate to the surrogates court physically within 2 days. The surrogates court also requires proof that the decedent's funeral has been paid for in full, as we discussed earlier with the funeral bill. All petitions should be accompanied by an affidavit of heirship. This is a sworn notarized affidavit from someone with personal knowledge of the decedent's family tree, and that person should not stand to directly or indirectly benefit from this estate. So it shouldn't come from one of the heirs. It shouldn't come from one of the heir's spouses. It can be anyone from a distant family member to a close friend or religious or community leader. Just has to be someone who's familiar with the family. The affidavit will state the relationship to the decedent or the family, the basis for their personal knowledge of the decedent's family, and a written outline of the family tree. Surrogates court petitions are court proceedings like any other, and anyone who has an interest in the estate, be it a beneficiary, an heir, or otherwise, has the legal right to be notified of petitions involving that estate because they're entitled to their day in court. Serving these notices and having these parties appear in court can delay a petition for months and cost thousands of dollars. However, if none of those parties, none of these interested parties has any objection, there's a way to bypass these notices and court dates. In a probate proceeding, each distributee, including distributees that have been written out of the will, along with all of the beneficiaries and all possible executors, not just the primary executor, but any backups, are entitled to notice that the will is being probated, and they're entitled to review a copy of the will and the petition. This often comes as a surprise to people who are disinheriting heirs or children, grandchildren, whomever. Those heirs are still going to be involved in the probate process, and they're given the opportunity to intervene and delay or derail probate. With the advent of virtual court appearances, they may be able to do so from anywhere in the world. However, if upon review of these documents, the interested parties have no objections and do not require their day in court, they can sign a document known as a waiver of citation and consent to probate, or waiver and consent. If all of the interested parties sign waivers and consents, no court dates required, petition is simply going to be reviewed by the surrogate. The surrogate is the judge of the surrogate's court. In administration proceedings, each distributee is entitled to notice that one of their fellow distributees is petitioning to become the administrator, and they are entitled to review a copy of that petition. Again, if the distributees have no objection to that petitioner's appointment, they can sign a document known as a waiver of citation, renunciation, and consent to appointment of administrator. If all of the distributees sign these waivers, renunciations, and consents, no court date is required, and the petition, again, will simply be reviewed by the surrogate. Finally, of course, for probate proceedings, the petitioner is going to have to file the original will. For e-file petitions, the will is going to have to be scanned one page at a time without removing any staples or fasteners. It is paramount that staples not be removed from a will, because removing staples can raise the implication that someone has tampered with the will by changing out pages. Like the death certificate, the original will must be delivered to the surrogate's court within 2 days of e-filing. Once an executor has filed their petition, the original will and all of the other documents, and paid the filing fee, they have to send notice of probate to parties with an interest in the estate who have not signed waivers and consents. The executor then has to file the proof of mailing of the notice of probate and wait for the court to issue a citation with a court date. Citation similar to a summons. It's a document that states that this is your court date, you should come to court. The executor must then serve the citation on any non-cooperating party via a process server at their own expense. On the court date, the non-cooperating party will have their opportunity to appear and make their objections. They may wish to contest the will, believing that it's fraudulent or based on undue influence, or they may have an objection to the executor themselves, believing them to be unfit or legally disqualified to serve. I'm not going to go into the minutia of contested probate, but these objections can tie up an estate in surrogate's court for years while the parties litigate their various positions and while the estate assets are being eaten away at by bills or fees or even lost to foreclosure or repossession. However, ultimately, the court will decide if the will is valid and if the executor is qualified. And of course, this can all be avoided if all of the interested parties sign waivers and consents. No notice or citation is required. The executor simply files all of the waivers and consents, and the court reviews the documentation without a court appearance. Once the matter is adjudicated, the court may require the executor to post a bond in the amount of the total assets of the estate. The cost of the bond is usually between 1/2 to 1% of the total value of the estate. So say you have an estate worth $500,000, the bond could be anywhere between $2,500 to $5,000. If the will is valid and the executor is qualified, the executor then receives letters testamentary. Letters testamentary is the term for the document issued by the surrogate, that's the judge, giving the executor the legal authority to represent the estate and handle the affairs of the estate. Financial institutions will now speak to that person and allow them to collect the assets and close accounts. The executor can transfer deeds to any estate real property to the beneficiaries. The executor can now resume or even commence litigation on behalf of the estate. Ultimately, the executor has the duty to collect all of the estate assets and maintain them until all of the debts and taxes have been paid, and then distribute the remaining assets to the beneficiaries in accordance with the will. Now, if the will is valid, but the executor is disqualified, a successor executor from the will can be appointed, or if none is available, one of the beneficiaries can petition to become the estate representative. If the will is successfully contested and declared invalid, and there are no prior valid wills, then the estate becomes an intestate estate and has to go through administration. So if there's no will, or a will is successfully contested, then any of the decedent's distributees, being those people who are entitled to an inheritance under New York state law, can petition to become the administrator. Again, this is known as an administration proceeding. For the sake of clarity, I'm going to refer to the specific distributee that's petitioning as the petitioner, because they're not going to become the administrator until this court process is complete. Administration is very similar to probate, but with a few key differences. The petitioner is going to file their petition and all the necessary documents, obviously not a will this time, and pay the filing fee as outlined earlier. And similar to probate, the petitioner is required to send notice of application for administration to all of the other distributees in order to give them the opportunity to object. Again, if there are distributees who object to the petitioner's appointment, the court's going to issue a citation with a court date. Petitioner has to serve that on all the uncooperative distributees, pay a process server, so on and so forth. The distributees then are allowed their day in court, and after all of these objections are litigated, the surrogate will determine if the petitioner or any other person should be appointed as the administrator. Again, if all the distributees are cooperating with the petitioner and they've signed the waiver, renunciation, and consents, the notice and citation process can be completely avoided. The petitioner files all of the waivers with the court reviews the documentation without a court appearance. The surrogate may again require the posting of a bond based on the value of the estate. Ultimately, one of the distributees will receive letters of administration from the court. Letters of administration is the term for the document issued by the surrogate, giving them the legal authority to represent the estate and handle the affairs of the estate. Again, financial institutions will speak to them. They can collect assets, close accounts, they can transfer deeds, they can resume or commence litigation. Ultimately, they have to collect all the assets, pay the debts and taxes, and then distribute the remaining assets equally between the distributees in accordance with New York state law. As is now probably becoming clear, Administration and probate are time-consuming, can be costly, and are often frustrating endeavors. And in some cases, distributees or even beneficiaries of a will may not feel that it's worth it, especially for estates with little value. However, New York state law classifies estates valued less than $50,000 that contain no real property or land as small estates. And there's a simplified, streamlined procedure to deal with them called voluntary administration. Voluntary administration can be used whether or not there's a will, as long as the estate is valued at less than $50,000 and there's no real property. For testate estates, that's where there is a will, the executor is still going to submit the original wills of the court. The will is not actually going to be probated by a surrogate. It's going to be reviewed by the clerks. For intestate estates, any of the distributees is eligible to apply. In either case, the applicant submits a 3-page affidavit to the court, along with the original death certificate, family tree, an heirship affidavit, and a copy of the paid funeral bill, and pays a $1 filing fee. If approved, they'll become the voluntary administrator of the estate. Notably, the applicant will not need to serve any notice on interested parties or distributees, and does not need to obtain waivers and consents from those parties. Upon application, the clerks themselves will send a postcard to the interested parties or the distributees listed in the affidavit. If the affidavit is approved, the clerks will issue certificates specific to each asset or account, allowing the voluntary administrator to collect that asset. Each certificate is going to be specific to an individual asset, and there's going to be one additional certificate that allows the voluntary administrator to open an estate bank account so that they can deposit all of those collected assets. A voluntary administration is intended to be much quicker than probate or full administration because the entire process is handled by court clerks, does not require notices or court appearances, and is not reviewed by the judge, the surrogate themselves. All right, with that, I've arrived at the conclusion of our presentation on securing estates and surrogates court proceedings. Please note that this is just a brief glimpse into the complex legal procedures at surrogates court, but I would like to now open the floor to any questions. Oh.
Awesome. Thank you so much for that amazing, as always, presentation.